Hello, everyone. This is Mallory Flowers on behalf of Jennifer Schaus and Associates, and we are coming to you live from Washington, D.C. Welcome to our Webinar Wednesday series. Our webinars are held every Wednesday in 2018 at 12 p.m. Eastern Time, and our speakers range from accountants to attorneys and other industry professionals. The full schedule for the rest of the year is on our website underneath the webinar tab. In the interest of time, we do not take questions. Our speaker's contact info is posted on the last slide. So if you have any questions, please contact the speaker directly. The recordings are on our website under the Archived Webinar tab, as well as on our YouTube channel. All right, and this is just a quick blurb about us. Jennifer Schaus and Associates is based in downtown Washington, D.C., and we help both product and service companies with federal contracting. Our clients are domestic and foreign defense contractors and civilians. Our services range from market analysis reports to contract vehicles, including the GSA schedule. We can also help you with proposal writing and post-award contract administration. More information about our services and upcoming events can also be found on our website. So let's go ahead and dig into today's presentation, which is Contract Compliance, Review Paths to Success. Jason Lee is our speaker today, and you can learn more about his background on this slide. Thanks, Jason, for joining us. I'll hand the phone over to you now.
Thanks so much, Mallory. Really appreciate you hosting this webinar today. Good afternoon, everybody. As Mallory mentioned, my name is Jason Lee, and I want to take an opportunity to thank Jennifer Schaus and Associates for all their wonderful partnership over the years, as well as hosting this wonderful webinar series. This is probably my 8th or 9th session over the last 2 years. I run a small business called Incisive Intelligence Group, and we do a couple of management consulting services for bidders and offers looking to get funding from the federal government, state governments, as well as foundations. Most of these services are in the lane of proposal development and bid response to solicitations and to other offerings. We also do some financial analysis as well as contract compliance review and also some accounting services. I invite you to contact me anytime at my contact information, again on the last slide, and we can talk through a free consultation about your different needs and just about anything that you might have on your mind about different aspects of the bid life cycle. Well, let's go ahead and dig right into today's topic. As Mallory had mentioned, we're looking at paths to success for contract compliance. There are really 6 different areas, 6 critical paths that you're really going to have to worry about when you think about converting the commitments that you put in your proposal to a funding source into a contract for the first time. These stages are as follows: negotiations, framing the contract, terms and conditions, considering flow downs and other kinds of coverage for your team members on a team-based team, the time horizon or the area or the period of performance for the contract, and then finally dispute resolution. If we move to the next slide, I just wanted to briefly mention that we will not be covering, unfortunately, due to time constraints and because it's also out of the scope of the discussion, 4 different areas, and that would include legal review from an attorney's perspective, especially since I'm not a licensed attorney, but I can certainly refer anybody who is interested in a legal review to some quality attorneys here in the DC area as well as nationwide. We'll also not be talking about the real-time contract administration, all of the tactical logistics that go on in administrating the various different caveats and riders that you have in your contract. But again, we can certainly craft out another session here in the webinar series at a future date that does talk more about those tactical logistics if this audience is interested. We will also not be talking about contracts with various different teaming partners, rather focusing on the contract between you and the funder, as well as you and subcontractors that will be supporting you on the particular funding assignment. And then finally, we won't be covering modifications of contracts here. Again, that's probably more suitable for a dedicated webinar. But again, feel free to send in feedback and interest on that topic should you like to hear a separate webinar on those issues. All right, let's talk about what we will be covering. So in that first path to success, negotiations. This is the most important aspect of the process because you want to ensure that you are absolutely inclusive of all the different issues that are important to your firm and to your team, and that also cover you for risk management issues like liability, but also extend to what your best interests are regarding maximizing your profit, maximizing the benefits that you get during the performance period, the time that you actually have to complete the work, your ability and flexibility to actually pass tasks in between team members, and again, not to have the project too restrictive that would hinder your chances for success in meeting the metrics that might be required by the government agency that you're servicing or otherwise other funding source. Going back to the issue of best interest, what you want to definitely worry about with best interest is quantifying different metrics of what you identify is your standard of a acceptable contract, and then what you deem to be a premium, things that you could actually get, again, to benefit your company's assets and abilities to be capable to run the task that you've been assigned to do. You'll start off first with creating a short list of various different wants. What would you actually like to achieve? You create goals and objectives that basically cascade off of the commitments that you put into your proposal. So from all the things that you hope to have achieved from actually pursuing the solicitation in the first place, you create this wish list. Then you actually create specific goals on how you actually plan to benefit or profit, not necessarily monetarily, but actually profit even intrinsically from those different work pieces within the solicitation, and then create the metrics to say, how am I going to test that I'm actually succeeding against meeting those goals and objectives? After you've done that, you want to talk about things that will reduce the exclusivity and restrictions that might be from the other side. So certainly the government will want to restrict things like the use of intellectual property rights, the ability to actually modify the contract under certain terms. You want to be able to come up with a list of anticipated requests that would come from the other side, basically the wants from the government or the funding source, and essentially come up with a plan of how you would want to negotiate out any of those very strict restrictions, or I like to call it exclusivity. Usually the funding source wants to make something that's exclusive to them, again, with most maximal benefits to their interests, whether that be, again, intrinsically or monetarily. Once you've done that, you want to see if you can do a little bit of internet research, talk to some other bidders who have been in a similar situation and develop some comparables. So the best way to negotiate is to say that the government agency that you're dealing with, that they've actually struck a similar type of arrangement or an agreement with another bidder in the past, or that another agency that's very similar to them has struck a certain kind of contract that's actually been come to fruition. The idea here is you don't want to throw out something that's theoretical, saying that we should have a contract based upon these theoretical interests. This is kind of the right way to go. Rather, you want to say an actual contract was done by either myself that I was directly involved in, or I know of friends, associates, what have you, who struck a similar contract with an agency, and that contract was very successful. By using a realized use case, you're going to be able to convince the other side that those points should be actually put in place in this contract because they serve as best practices of the past. And then finally, you want to document all the progressions of the conversation. So usually you want to talk about anything substantive of things that you want in the contract or subtracted out of the contract, documented in an email. Usually you won't be able to record any phone calls depending upon, again, local and state laws regarding one-party, two-party states. So I would probably avoid that altogether and just go upon an email. Or if there's another way that you want to do certain kinds of track changes, and then essentially have a signed statement separately that says that each party agrees that their initials within the track changes, they will be committed to that, and they will agree if there's a dispute later that they agree that that's associated with their identity. So I highly recommend a strong documentation process. If we move to the next slide, let's talk about the next path to success, and that's essentially framing your contract. How are you going to actually bound the verbiage? Because usually when you start out, you feel overwhelmed and ask yourself, what do I talk about? How do I address these issues? Where do I even start, especially if this is your first contract ever with this particular funding source? Well, the first piece of advice that I have is be direct. Say exactly what's on your mind. Short, brief sentences that are not flowery and that do not leave a lot to interpretation is your best way to go. Obviously, the legal field is known for having things that are very much explicit, but even from a lay point of view, what you want to do is state exactly what you want and what the outcome should be. And then also frame, whether that's going to be a long-term implication or a short-term implication. The second piece, along with being direct, is being very specific. So you don't want to actually make a laundry list of the different items that you want to have included. Rather, you want to create some common terms of reference, and that might include creating a glossary or some kind of index at the end of a particular chapter or section or rider within the contract. But whatever that needs to be done to create those terms of references, you'll need it in order to become very specific in your language, so that this way each side realizes what the vocabulary words, the verbiage that's being used, really references to, again, with little interpretation. Third, as we talked about, be inclusive. So you don't want to necessarily worry about being exhaustive. If you could exhaust all the possible issues that could affect your firm, affect your team, affect the performance during the contract, that's great. But again, that's an overwhelming exercise. So the idea, first of all, is to start off with brainstorming on a piece of white paper and writing down exactly what you think would include pretty much 90% of the things that you have to worry about, both good and bad, things that you want to worry about in terms of maximizing, the best that you can get out of the project, again, monetarily as well as intrinsically. But then also you want to talk about the risk management issues and then articulate what are the bad things that could happen to me if I were ever fell breach of this contract, or if the contract somehow fell short, not covering an issue, and then there wouldn't be any guidance for either side to actually resolve that dispute. So those are the things that you want to think about in the brainstorming exercise, and then be able to kind of factor that in when you're having your discussion, so that this way, every single rider that you have in the contract is representative of, again, 90% of the issues that you care about. Fourth, be decisive. So instead of actually providing too many options or too many caveats saying that under these following circumstances, these following consequences are going to happen, try to bound that down. It's okay to provide some options, maybe 2 or 3, but once you start going beyond that, there becomes a lot of wiggle room to create what folks often call as loopholes. And usually that's another reason why not to try to aim to be too exhaustive, because if you're exhausting all the different possible combinations of outcomes, you're essentially creating too broad of a scope, allowing, again, the other side to potentially find a way to get around one caveat by claiming that they're actually adhering to and complying to another caveat of the same contract. Finally, you should consider external factors. So don't only think about things that you have within your direct control, but what are the things that happen circumstantially, the outside forces that actually could rain on your parade, again, provide some of those risk management issues, or external factors that could actually benefit you. So again, you want to think about listing out what those external factors are for yourself, not necessarily putting them into the contract, and then talking to those external factors about what you, in terms of your side, is going to do about addressing those external factors. Some of the external factors you may not want to actually share with the other side, thinking that it would actually be to your disinterest to make them known, and that's something, again, that you're going to have to figure out in that brainstorming period. So that's the second stage. The third stage on the next slide is coming up with your actual terms and conditions. So this is actually formulating the caveats and riders within the actual contract itself. And what do you have to worry about here? Well, the first thing is assumptions. What are the actual footnotes, if you will, of basing each rider in terms of what you and your counterparty is expected to do with following the contract. These assumptions should be, again, clear and specific, as we talked about in the other slide, but also these assumptions should also be something that is stagnant and won't change. It's something that is fairly obvious and is not going to be something that that could be disagreed upon at a later date. So these are the foundations of the riders that you're going to have in the contract. The second piece is the responsibility. So exactly what will your side, what will the counterparty be actually doing when they are executing on these riders in order to be compliant? And what is outside of those responsibilities? So certainly you're going to want to provide a warranty, if you will, of saying that I will do these things, but here's some other things that I definitely won't do. And you should actually articulate that instead of leaving it saying, if it's unsaid, then obviously that's something I won't do. I don't think that that'll be strong enough. Again, I don't want to get into the legal type of context because that would be more for an attorney to speak to, but I think for a best interest situation is someone can certainly say if it's unsaid, it's something that we didn't think about and it's something open to negotiations for a contract modification in the future. So again, that can undermine all the hard work that you've done in terms of creating these assumptions and creating these foundations here in this third stage. We talked a little bit about caveats earlier, but that's the same thing as assumptions. In terms of caveats, it's just the circumstantial conditions that you want to place on your counterparty and letting them know exactly what situations that you'll be willing to execute your responsibilities in the point above and which other exceptions you will not be actually agreeing to entering into your responsibilities. It's outside of scope. And then finally, we want to talk about those indirect effects. So this is where you're going to want to take that list that you did in the previous stage and share with the counterparty the outside effects that you're willing to make known, and to also solicit some of your partners as well, especially if you have subcontractors, vendors, other members of your team, to figure out what are things that will affect those outside institutions that could actually roll back to you. And then you're going to want to include that in your negotiations discussion, and then obviously, like I said, factor that into the final verbiage of the riders and the caveats here at this stage. The next path to success on the following slide is considering your flow downs and other coverage. So this is basically related to your traditional FAR and DFAR review, taking a look at what the government, in most cases, at least with the FAR and DFAR, require you to do in terms of passing down the requirements that you have as a prime to your subs. So you're going to have a responsibility to train and to guide those subs and make sure that they're just as compliant, because any kind of non-compliance by them will roll back to you. And that's where the flow down goes. And in some ways, there is a flow up in the sense that, again, if there's a violation from the flow down recipient, it could affect you as the prime. The one thing you want to do is not look at flow downs too restrictively. So again, read the language for face value by the requirements, and anything that's not in that FAR guidance or anything that looks to be subjective are things that you're going to want to make a list of and either address them with the contract trade representative or the contract officer. And then if that person is unable to kind of give you guidance because it may truly be a gray area, then what you're going to want to do is have a discussion with your subs and your team members to determine, okay, what if something does happen in these gray areas? Are we going to flow down on those type of issues versus which ones we will not require you guys to flow down on? So that kind of thought process, to do it in a concerted way, is going to be important, because later on in an audit, they are going to want to see if you've actually made that kind of thought calculus. And usually, if you have a very stringent and systematic thought calculus, if something does fall through the cracks in an audit, there typically won't be a violation. It'll just be something that neither the prime or the sub had thought of in that brainstorming area, and it usually would carry off with a warning if there were a violation to the FAR. So that's kind of the importance of looking at flow downs in that way. Other coverage that you're going to want to really consider is coverage of teaming partners that are not subs. Again, vendors, joint venture partners, consultants, especially independent consultants, 1099 consultants to your performing project. How will these individuals, their work, mistakes that they make, hopefully good things that they do, obviously will affect your firm, because obviously you want to take a benefit of great things that they might do above and beyond, and then of course anything that they might incur in terms of liability, you're going to want to bifurcate and protect your core team with. So those are some of those issues that you're going to have to worry about with vendors and liability. And then the last, or second last point on this slide regarding supervision is being able to have a monitoring apparatus. So not just having a program manager during the performance period of the contract to actually, have oversight, but you actually have to determine a work plan of what you're going to do on a day-to-day basis with contract compliance. How will you actually detect a non-compliance event? How will you actually provide some kind of sanction to whoever on the team that you determine is a result of a non-compliance, and what will you do about it? And then, of course, what will be the reporting for transparency purposes back to the funding source, back to the government agency. All right, let's move on to the next path, and that's basically time horizon. In terms of time horizon, you're mostly worried about the effective performance dates. When is the project going to kick off, and then when is it going to end? What are the different milestones in between? There has to be some kind of clear definition of the time. You don't want to leave it too open-ended. Otherwise, there could be potential impact at the end, for instance, even when you do contract closeout, that your counterparty might say, even though the contract's been closed out formally, there's still kind of a informal period after that that allows us to mention any kind of mistakes or things that we did not like after the project had been wrapped up and we had done a performance review. We want to protest some of the things that we didn't catch at contract closeout. So you want to make sure that there's a lot of clarity regarding the time frames that you're actually articulating and talking about in the contract. Secondly, with the riders and the overall contract expirations, each individual requirement should indicate if there is a time requirement. And so if you're unsure if you should mention a time requirement for a particular caveat or rider, individual bullet point in the contract, put one in there. If you don't put one in there, again, it'll be left unsaid and it'll be open to dispute. Grace periods. You want to talk about what happens if a deadline is missed. Is there any kind of little bit of forgiveness that you're willing to give or that you're willing to accept based upon grace periods put onto you by your counterparty? And then finally is the positive or passive acknowledgments. So what we mean by positive is that you make an affirmative statement. Usually you've seen that in employment contracts. I acknowledge that, everything in here is the best of my knowledge, that kind of thing. That's a positive statement. And then a passive one is more of that the parties agree that if certain situations were to arise, X, Y, and Z, then this document would then be void or some other kind of consequence would happen, and that's more passive language that says that, both parties are pretty much in agreement. It's not really a affirmative acknowledgement. All right, finally, let's talk about disputes, which is the last path to success. Hopefully you never get to this stage, and hopefully there's never a dispute in your contract, but it is the sixth stage that usually ends the process because, again, most efforts, especially if they're sizable monetary engagements, and especially when they're with bureaucratic organizations, again, federal and state, local governments, something is going to arise with a disagreement. So you're going to want to do, number one, in that first bullet point, a resolution process. What does the business process look like once you have a disagreement? What are the different elements that are going to take place to actually adjudicate that issue? And then who is going to be actually the decider? Are you going to bring in a mediator or an arbitrator, or are you going to follow a totally different process? So those are some of the things that you actually have to nail down in writing and be able to articulate, again, with that clarity and that specificity that we talked about all the way back to path number one. Second is cascading from law and policy. So the best way to do things is to cite to a precedent, cite to policy, and usually you can really use, especially with, again, a government agency, use their policies to your benefit. If they have different rules, you want to make sure that they adhere to their own rules. In some cases, maybe their rules may not apply or provide maximal benefit to you, so you're going to want to actually take a look at outside agency rules, and maybe there are other federal government stipulations that that specific government has not mentioned within its own regs. However, you're going to want to talk more holistically and say, well, here are some regs that are done by some oversight agencies or maybe from another branch, let's say taking some policies from the legislative branch and saying that even though the executive branch has not mentioned these, the legislative branch has put out this guidance that says that all branches of the federal government should follow. So where possible, cite to other people's policies. It'll show that you're being fair, that you're not trying to create your own rules and saying, these are what I believe the rules should be, and so therefore that's why it's in the contract. You're citing a third party, and you're just citing that you believe that those are best practices, and you believe that both parties, you and your counterparty, should both adhere to them. The last piece of advice that I have is to designate a dispute coordinator, some kind of POC. Now, you don't want to do anything specific by name because you're not sure if that person is going to remain, a Robert Smith or a Sally Smith. You don't want to use the person's name. You're going to want to use a title or a role, obviously, within your team or your company, and designate that person as the primary point of contact to actually speak on behalf of both organizations. This way, in the dispute process, you won't have too many cooks in the kitchen where everybody is speaking to the issue, whether there's a dispute or not. All right, well, we've gotten to the final slide here, and I think our time together is up, unfortunately. I invite you to contact me directly. I know this is pretty much high level, but there's certainly much, much more that goes on within the weeds and in the trenches, and I'd love to kind of provide consultation services to anybody who's interested in, again, a free 1-hour consultation, and if you'd love to sign up for services, hopefully I can help you as a client. So with that in mind, again, I want to thank Jennifer Schaus and Associates for the opportunity to talk about these very important contract compliance issues. I'm going to turn everything back over to Mallory now. And again, I look forward to hearing from everybody after the show. Thanks so much for your time.
Yeah, thank you, Jason. That was a lot of great information. And thank you for sharing your time with us today. And thank you for everybody who joined us. If you have any questions for Jason, like he said, please contact him directly with the contact information you see on your screen. Next week, we are covering commercial item qualifications and determinations, and this concludes our webinar. Thank you, everybody.